Good day, and welcome to Epstein Becker Green's webinar, Privacy and Behavioral Health, Much More Than HIPAA. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. You are welcome to submit questions directly to the presenter following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. We are pleased to have a fantastic speaker today. Epstein Becker Green's Patricia Wagner is a member of the firm in the healthcare and life sciences and litigation practices in the firm's Washington, D.C. office. She also serves as the firm's Chief Privacy Officer. At this time, I'd like to turn the webinar over to Patricia Wagner.
Thanks, Whitney. So I titled the presentation today, Privacy and Behavioral Health, Much More Than HIPAA, but you're going to have to forgive me for a minute because we always start with the privacy rule. And first, 2 reasons for that. 1, I want to make sure everybody is level set on the privacy rule, and 2, because the privacy rule is pretty encompassing. It protects all PHI, medical information, health plan information, mental health information, substance abuse treatment information, so it covers the waterfront. So we want to make sure that we always are thinking about the privacy rule when we're thinking about protecting behavioral health information. Importantly, particularly in the behavioral health context, the privacy rule only applies to covered entities and, of course, their business associates. And as you know, to be a covered entity provider under the privacy rule, you not only have to be providing care, but you have to be utilizing a standard transaction, and usually that occurs in a billing situation. So as you can imagine, there are treatment facilities, for example, those that are only private pay, that never cross the line into being a covered entity. On the other hand, there are a number of treatment facilities that would be covered entities, or if they are not yet covered entities, are anticipating starting to bill payors in the near future, and so they would be covered entities. Now, the mantra of the privacy rule is that protected health information cannot be used or disclosed without an authorization. There are, of course, exceptions to that in the privacy rule, otherwise the medical world would stop in its tracks. And the 3 exceptions that we are most familiar with are those uses and disclosures that are available for treatment purposes, for payment purposes, and for healthcare operations. Treatment and payment are pretty self-explanatory. Healthcare operations is a nice one. It really addresses the ability of an organization to use and disclose protected health information in transacting some of its business operations. And for purposes of a transaction, healthcare operations is a very nice niche because the definition of healthcare operations includes uses and disclosures for sale, transfer, merger, or consolidation, and the diligence related to that transaction. So pulling back a minute, thinking about the privacy rule and its impact on due diligence or transactions, the privacy rule actually has provided a pathway through for organizations so that diligence can occur, claims review could occur, all of those things that you might want to do in a transaction so you can get a better feel for the company that is potentially being acquired. So that's the good news. Now for the more challenging part, and this is 42 C.F.R. Part 2. This is a provision that relates to the confidentiality of alcohol and drug abuse patient records. And again, this will apply to every entity, but where it does apply, it's very important to be aware of the constraints of Part 2. So first of all, 42 C.F.R. Part 2 applies to federally funded individuals or entities. Now that can be direct or indirect, and the easy example is if an entity is receiving Medicaid or Medicare payments, that would be a federally funded organization. Or, for example, if they're receiving a grant, like perhaps an FQHC. In addition to receiving federal funding, they have to hold themselves out as providing and provide alcohol or drug abuse diagnosis, treatment, or treatment referral. Now, this can be an entity in its own. That's the sole purpose of the entity, for example, a methadone clinic, or it could be a unit of a hospital where perhaps there's a treatment portion of the hospital, a unit in the hospital that is covered by Part 2. When you think about 42 CFR Part 2, you have to remember that the overriding principle was to protect individuals who were seeking treatment for their alcohol or substance abuse. So the government is very concerned that that information stay confidential, to prohibit any discrimination against individuals who are seeking that treatment, or to help those individuals not have issues, for example, getting jobs or renting apartments or doing all sorts of other things. So because of that strong underlying purpose, 42 CFR prohibits disclosures without written consent. And there are very, very few exceptions to that blanket prohibition. The consent itself is pretty stringent. There are a number of required elements in the consent that have to be present. And notice that there's no exception for the treatment, payment, healthcare operations. It does not track the privacy rule. It is much more limited than the privacy rule. There are some limited exceptions. It would be a lie to say there aren't any. There are some. Obviously, emergencies would be a good one. Disclosures to an entity with direct administrative control, and disclosures to qualified service organizations. And those, in general terms, really tend to be the vendors of the substance abuse treatment program, for example, the accounting firms or the legal firms, or perhaps a billing vendor. Now, the other thing to remember, to make it more complicated, is that not everything captured would necessarily be protected under 42 CFR Part 2. So, for example, you could have a facility that qualifies as a substance abuse treatment center that is treating someone not only for substance abuse, but for hypertension. Arguably, the hypertension would not be covered under 42 CFR Part 2, so that information could be treated as if it were under the privacy rule. Converse to that, treatment for a disease that is associated, for example, with alcoholism would probably still come under the requirement of limited disclosures under 42 CFR Part 2. Now, when you think about this, you can imagine in a world of population health management that such stringent controls on this information could create issues, particularly for a group of people where you really might want to make sure there is a lot of coordination of care. There are proposed regulations. They were issued on February 9th of this year. In addition to clarifying some definitions, they give a nod to the fact that the way that 42 CFR Part 2 is currently constructed could negatively impact population health activities, and they are proposing a solution to that. The solution, I might note, is still not privacy rule disclosed for treatment, payment, healthcare operations, but it is more a less stringent consent, a consent that allows more general descriptions of the type of information and to whom the information will be disclosed. So when we think about, again, I'm trying to pull everything back to a transaction framework, when you think about looking at a facility in a diligence, if the facility is covered under 42 CFR Part 2, recognize that you may have very, very limited information to some of the information. So, for example, if you want someone to be present to do a claims review or have somebody looking at billing and collecting, they may have very serious limitations on the information they have access to. In addition to that, you want to make sure that the entity that you're looking at actually has processes in place to recognize the importance of getting consent under Part 2. And you have to be thinking about going forward how those processes are going to fit into whatever business plan you might have. As I just talked about, if part of the plan in acquiring an entity is to be able to fold in some population health management characteristics, you'll have to be thinking about how you'll be able to do that under the constraints of 42 C.F.R. Part 2. Now, if that's not enough, we now have to worry about state mental health laws. And actually, it's state mental health laws as well as state substance abuse laws. So, as many of you know, there are a fair number of organizations who are operating in the behavioral health or substance abuse treatment space that would not actually either be a covered entity, for example, because they're all private pay, and for that same reason, they would never be covered under 42 C.F.R. Part 2 or are not yet covered under 42 C.F.R. Part 2. So while you might think that that's a home run and so now you're home free, in fact, you now have to start thinking about state laws. And state laws often have a reference to 42 C.F.R. Part 2 as the standard for protection of information for alcohol and substance abuse treatment facilities. So even if an entity is not technically being federally funded, it may have to meet the same requirements of a 42 C.F.R. Part 2 facility because the state law is going to require it. Many states have similar protections for mental health information or stringent protections for mental health information. As just an example, the District of Columbia just recently changed its law to allow disclosures of mental health information for treatment purposes. Before that, you had to obtain a consent to disclose information for treatment, mental health information for treatment purposes if the disclosure was outside of the facility. And as you can imagine, that being able to release that information has a tremendous impact on the ability for organizations providing mental health treatment to participate in health information exchanges. Just one note on the District of Columbia, the consent for other disclosures is still in place, so for payment and healthcare operations, you'd still need a consent. And the District of Columbia has a one-year limitation on that consent. Now, I wish I could say the District of Columbia was unique in that regard, but every state has its own quirks. Every state will have different ways of managing mental health information and the consents that need to be in place to use or disclose that information. And so again, thinking about it from a diligence perspective, if you have an entity that's operating in one state, that's a pretty easy place to get your arms around. But if you are looking at an organization that has operations in multiple states or is planning to operate in multiple states, you'll want to be thinking about the different state requirements in each of those states in which it's operating. I want to just circle back to HIEs. Mental health information, many states have various takes on mental health information in an HIE. Some states initially roll out and suggest that mental health information should never be in the HIE. As you can imagine, that becomes challenging as providers try to figure out when information trips the line between mental health and medical information. But again, it is something that's going to be a state-by-state requirement and a state-by-state issue to look at. Again, circling quickly back just to diligence, if you're looking at a target, You'll want to make sure that the target understands those state law requirements and has processes in place to adapt to them. So you'll want to make sure that whatever target you're looking at understands its position in the market, and to the extent it needs to is complying with the applicable federal and state requirements and understand the impact of those requirements on the business going forward.
Thank you. We'd like to welcome everyone to submit questions directly to the presenter following today's webinar. For those of you that have presented questions through the webinar platform, I will make note of those and share those with Trish. But you can also send her an email at pwagner@ebglaw.com. So please feel free to follow up with Trish directly. We hope you'll join us for any of the upcoming webinars in this series every Tuesday in March at 2 p.m. ET. For additional details or to watch recordings of previous sessions, visit www.ebglaw.com/events. Thank you for joining us. This concludes today's webinar, and approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you.